Hey all, here is a replay version of the most recent live stream Q&A on all things Social Security that occurs every Wednesday at 1 p.m. Eastern Standard Time. So this is with all the little silences carved out of it. So I hope it's an easier listen for those who are doing the replay versus being there live. And we'd love to see you live. So feel free to pop in. Bye-bye now. All right, guys, can you hear me? Let me get my comments on. Happy Wednesday. RD, I see you down there at the bottom. Can you hear me? Just let me know, guys. Yes, we can hear you. All right. Thank you, Beth. Beth Prince, good to see you. So how are you guys doing? I'm not even back at the old homestead yet. I'm out in Central PA. Came up from the Jersey Shore for a long weekend. That was kind of cool. I'm going to turn off my phone. I don't even have a prepared list of some daily videos I've been liking sharing with you guys in the very beginning as we get started. But that's okay. They'll still be coming out. I just haven't had really time to look and see what's queued up. All right. So I did see Eddie Garcia was here bright and early, really early. Totally get that. And we may as well just start going through it. Okay. So I hope you all had a good week, though, and a good weekend. So Eddie says, good morning. Been watching your videos and have, okay, he's been very kind to me. I won't read it out loud because I get a little embarrassed. Okay. So Eddie, I know we spoke, was that last week on here, actually? So you are a representative payee of a minor child who's on, I guess, SSI, right, Eddie? Okay. Eddie says, if I withdraw, I put it on, right? Yep. If I withdraw cash from the monthly account or the dedicated account, so again, this isn't, I believe, an SSI minor child, do I write down an explanation of the expense? For example, quote, this was used for this on this date, and keep that in a folder. Not a bad idea. I would also say if you can avoid just doing straight cash, annoying me, and that's supposed to be off. Oops. You know, like if you can Zealot, or I'm just thinking because then you can have memos and it will come out in your bank statement from your bank. So it's clear, you know, when we claim that we pay cash, who's to say whether we did or we did not? Now, if you got a receipt signed by the recipient, but you know, how much does that actually document too? I mean, anyone could sign anything. You could throw a Mickey Mouse signature on there. Although I don't see them, Eddie, I think we talked about this before. I don't see them coming down hard on parents because parents are probably the most reliable RPs there is for their children. You know, they're the, and while there are weird exceptions, you know, it is something that they understand. These people are the ones actually putting the roof over their head. But if you wanted to be super careful, you know, maybe, you know what, I know you don't, I think I saw down further, you don't have checks yet for the bank account. So yeah, if you have to do cash, I would keep a journal. Do you keep a register? Because if you have it in the account, there should be is there an online register that the bank gives for that dedicated account, Eddie? And if so, do you use a register where you, like, I don't know, I use, what is it? Same thing that goes through, I think it used to be Quicken, and I think now it's Intuit. I'm not even sure, but anyway. So you can go and automatically download those things and adjust what they say and add things to keep your register accurate and in a way that you're going to understand it. You know, there's a memo section. You could do that. But yeah, I would, if you're going to be, like I said, I think they're not as tight on parents as they might be on somebody else who's a representative payee. But if you want to be careful and just do everything by the book, yeah, I would go ahead and just keep a running total of those cash things. In the future, if you can write a check, so that's great. Or if you can electronically send stuff, you know, we have Zelle and I feel like this is so much in my face. Do I feel like, it seems like I'm in your face, guys? Sorry. All right, let's keep going. Eddie's got a few more. He just banged him out here early, I think, just to get him in. I don't blame you, Eddie. If get a babysitter caretaker and pay them cash, should that be in a written agreement? No, but I would keep it documented. I mean, you could, well, you don't have checks. Again, you know, check into that Zelle and stuff. That's an easy way to send stuff if your bank has it for that kind of account. I don't know that you have to have a written agreement, but document in your calendar that you went out and you had babysitter so-and-so and how much it cost. And that's, you know, that's documenting in real time. So there's even ways we can almost get that into court if we ever had to. Not that you're ever going to have to go there, but a copy of your written calendar, like a picture of the page if the SSA ever asked about it. I don't think they're going to ask about that tiny little stuff. Again, you are putting the roof over the child's head. Technically, all that money could probably be his share of the shelter. And then everything you're doing on top of that is just you giving money for the welfare of your child and that kind of thing. So I wouldn't get yourself too hyped up about it. But again, if you're going to be going by the book, and what maybe we would say to a third party that's handling their friend who became disabled, monies for them, those people have to be really careful, because there has been a lot of swindling by RPs against supposed friends they're taking care of, who they're probably virtue signaling for as they rip them off right and left. But it doesn't really apply to parents. And when using back pay in a dedicated account, again, SSI for a minor child, to back pay someone who has helped with rent, do I need that's probably a bigger amount. Remember, if it's a dedicated account, it's your son's money, so your son owes somebody for rent. If you already paid back that person from your own money, whoever was helping you, let's say your brother Joe, and you paid him back yourself, and now your son's going to pay his portion of that rent that you had footed, from the dedicated account, which is devoted for taking care of his basic needs like that. I would think that a bigger back pay, you're going to get checks any day now, right? I mean, you can technically order them online. You don't have to get them through your bank, and they could be cheaper online too. So usually it takes a few weeks tops for checks to arrive. And the good thing about checks is you have it in the memo, and that person actually counted it, cashed it or deposited it, and the money can be, if it ever had to be, which I don't foresee this, Eddie, it can be traced by banks and the whole banking system. That's what the routing numbers and everything are for. So Eddie's saying he does still have a couple of weeks before he gets the checks, but because I have things that are past due and people I owe who have helped me, I'm trying to dot my I's and cross my T's beforehand. I get it. You have your own bank account. Why don't you pay them? Unless maybe you just don't have it, which probably is true. And then you could have your son pay you, but just always document in those memos where it's going and what it's for. If you ever have a bill that you're paying, keep a copy of the bill and say paid out of account number. I don't know what your son's name is, but Johnny's account number, blah, blah, blah. So you could see the bill and see where it's paid from. And it's also going to be showing up hopefully on the bank account register online. Or if you do keep your own version, like on Quicken or something. Eddie, I hope I have a fantastic rest of my week too. So far, it's been really good. It was a great weekend. It was really good family time. And we don't really get that too much, so that was really good. Eddie says, I will be obtaining a normal card so that I can purchase your package offer on your page. I'm not sure what you're referring to. I tried with my Cash App, but it did not work. In the meantime, enjoy getting insight from your videos. Oh, I'm glad you're enjoying them. I'm not sure about a normal card. Are you talking about like a debit card from an actual bank? Yeah, I kind of don't play too much with Cash App and stuff like that. I do have like PayPal, and I have like personally, and I have Venmo because I have a Venmo card. But I'm not into the Cash App stuff. I'm not into anything that's not at least somewhat, I don't know. You always hear too many nightmares. So Eddie says he did get a lot of info from SSA government website, but it wasn't decent enough for my simple mind. You don't have a simple mind. You know what it is? It's too simple for people who have more critical thinking and think deeper and want to make sure they're protected. So I don't blame you, Eddie. I really don't, because the SSA.gov site, like any site, is going to be the lowest common denominator of reader within reason. You want to be able to cover as most people as you can. You're still not going to be able to cover all. There's some people that will never be able to read, understand, severely disabled from a cognitive point of view. Yeah, they do try to keep it pretty simple. And it's kind of like, it reminds me of the way if you call, no offense to the SSA staffers, because, you can't know everything while doing your job. Like all of us, we're always trying to stay on top of everything. But like an SSA staffer gives out information on the phone. Sometimes they give out the general answer, but there's like 5 exceptions, and they never asked the person if any of these 5 exceptions occur, which completely changes the answer. And I think that's part of the reason why people get misinformation from, calling up the SSA. And in theory, that can happen from the SSA.gov site too. It gives a general overview, and hopefully it says it on there. This is general. There could be exceptions. They should probably have that disclaimer, but I don't know if they do. I forget. Yeah, right. We talked last week with Eddie about his son potentially owning a vehicle, son who doesn't drive. He's a child, but they don't have a vehicle, and the child needs to get to medical appointments, therapy appointments. You know, someone needs to go out to the grocery store and buy food. Otherwise, you're paying exorbitant prices with, Instacart or one of those. And I shouldn't say exorbitant, but you're going to pay more. But I'm glad you looked into it. Good. Sometimes that's just all you need is to know, is it potentially a possibility? And if it is, it gives you a reason to go spend some time researching it. You might find out it doesn't fit the bill for you, but at least knowing that it is a possibility and then going out there and finding out. If we don't even know, it's not even a twinkle in the eye, then we don't go out and, try to find out if it's so. Dimple. Hi, Dimple. I hope you're feeling okay. Hello from Ohio. Oops. That's just a little self-advertising right there. So this is You Served, You Deserve. Oh, that's sweet. So You Served knows a guy, and he's 66 on SSDI. Can he do a trial work, period? Or how can he keep his benefits until 67, staying under SGA? Of course. Yes, he can. And if he does start to work You Served, I think he should notify the SSA right away, send them a letter, maybe certified return receipt, and or calling them. I like to have that little receipt, though, that proves that you told them. So there can never be an issue about, well, how good were your intentions? You never told anybody you were working, And, starting to work can prompt a CDR. And they delve into what kind of work you're doing, because even under SGA financially work can still be SGA if it's something that would clearly be worth far more money than SGA if a regular pay was being made for it. I assume that's not what he's going to be doing. So I think it's awesome. And he can make a little extra money. And then when he turns 67, which is right around the corner. And by the way, it wouldn't be a trial work period You Served if he's under SGA. That only starts if one starts to earn over SGA. So that's okay. You trial work. Yeah. We all have our typos, right? I have them all the time. Virginia Gomez, nice to see you. Good morning. My lawyer filed a disagreement, probably an appeal of the ALJ decision. I think that's what you're saying. What is the percentage of winning after it is sent back to ALJ, if it is sent back? This is SSI. I think you're 52 years old, and this is your third year after you filed. There is no, I'm not aware of any publication. It'd be nice if they had all these details available to us, where a remand back to an ALJ where you won it at Appeals Council is then flipped. I will say SSI versus SSD can be helpful because there is no DLI, date last insured. So the ALJ can look at your evidence all the way up to the present, the time of the new hearing. If you had a DLI that was in the past because you haven't been working and it runs out, that would be a different story. You're trying to get the judge to overturn his own decision that he made before when you got nothing new to add to it. That's going to be tough. I think if that was the case, an ALJ would be, I'm just speculating here, probably not going to do it. But when you have other SSDI and a DLI that's at least a good deal after his decision, preferably in the future, that's what I'm always saying. If you can work a little under SGA and keep your credits going, you can really end up winning when you thought you were going to lose and never be able to get SS, at all. So I don't know that there is a stat. I will say that we have a really good prevail on remand rate. Like I said, I'm not even sure if we ever lost one on remand. You lose the first one, then you do. But maybe there was one, or one years ago or two. But it's really important to go back and see, Virginia, if the judge didn't have. This is the best way to get him to, I think, to perhaps reverse his whole decision, or at least give you, a future onset date so that you have prevailed now. The new evidence, and if there was any missing from your old file, from that time period that he already adjudicated on that is being reopened due to the remand. So you have a chance to get that whole back thing, not just forward thing, which you have too. Not having any new evidence that was missing from there, I think can be not a good thing. Of course, if you were really diligent and provided all your evidence back then, you're not going to have missing evidence. So it's kind of funny in that way. But it's just something to think about. If you can think of anything you might have forgotten about, maybe some or something, like something that maybe wouldn't be so wonderful of evidence and that's maybe why it was overlooked, like a little Cairo, which might not mean too much. It's not the strongest of evidence. Obviously, it's like a missing MRI that showed spinal stenosis and nerve impingement, that would be big. That would be big. If you go through, and also go through your denial letter, look at all the, kind of have to go line by line. It's really nitpicky. Find out, try to read it while thinking about every line you're reading, and don't get like glossy overboard, and try to pick out what he or she said that was part of the crumbs that built the denial, and see if you can't change those, with new evidence now or something to that effect. So, because you know what he honed in on, and maybe you can eliminate some of those things that he tends to hone in on. Oh, dear. Hi, RD. Hello from California. Hello to you too. Beth Prince. Happy Wednesday. Yes, we can hear you. Yeah, I appreciate that you said that, Beth. Because if you guys all recall, when we first started doing this, I was trying to get the whole tech, all lined up, like, oh, no one can hear. Oh, that's right, you have it on mute, or your headphones, because I wear these. I don't know if you could see. They're awesome. I love them. Virginia had said yes. Temple says, has the time frame of the initial decision decreased any in the last few months since they have been working on it? Yeah, in fact, I think I just didn't. I don't know if it's queued up yet, but I think I just had one that, and I don't want to mix up my numbers because we talk about field office decreases in time. Then there's DDS, which is really the initial decision and all that, and the recon decisions. And I think both have sped up. Now, granted, they're speeding up from molasses, so it's still kind of slow. But, when it increases, it goes better by 25%. That's better than what it was continuing to slide in the wrong direction for a few years there. Jeffrey Taylor. Good afternoon to you too, sir. Oh, Beth asked, what did you find in your new hobby? Metal detecting? Not a thing. I am actually learning the machine. It's a little complicated, but there was people on the beach and I didn't really want to do it there. I think I'm going to do it. I live in the Poconos. I'm not there right now. I'm in Central PA, but this could be a good area too. I don't know. The Poconos was, really a place with a lot of Native Americans, American Indians, if you will. I think there could be, some good stuff along that vein, maybe. I live in a development. We have a community center with a soccer field and tennis courts and all that. I'm like, that might be something. We also have a swim lake with a beach. I'm tempted to go down there and start collecting on some of the jewelry. Some of the moms might have slipped off their finger that can become mine. Just kidding. But no, I'm not actually kidding. That's really what I intend to do, because this metal detector, and I can thank my friend Tim, goes underwater. So if it's like this long, as long as I don't get it up over the computer part, which is up by the top by your hands, it's waterproof. So I can go under a little bit of water. And then my friend got me something called a pinpointer, which, if I understand it right, I can swim underwater with that bad boy. Not sure how much I'm going to do that, but my husband ordered, and it didn't come in time for our trip this weekend. He ordered some sort of underwater, super cheap, so it probably won't work, but an underwater breathing thing. And I don't mean a snorkel. It was something seemingly a little more sophisticated than that. Now the snorkels aren't great, I'm sure. I mean, I know as kids we use them, because I grew up with a little lake and we had a beach and we'd swim in it. My dad used to make the beach along with my neighbor who actually owned the whole farm. We just kind of rented. Valerie McKenna's in the house. Hey, Valerie. Good morning. With the new bill signed into law by President Trump with the work requirement on SNAP and Medicaid, does that apply to us? Or Social Security is totally different from Medicaid and SNAP. Those are local programs. And I don't know what that bill says, Valerie. I assume it means for people who are not disabled. And if you're on SSD, you are found legally disabled by the federal government. So I knew what had been touted, and I'm sorry, I'm not up to speed on it. We had no news on for like last week. And I'm sure this was something from before that. But what they were talking about was simply not letting healthy, able-bodied people just collect out of the welfare funds for those that can't work. And at least requiring them, if they're, work and have low income, and now you're trying, and we'll supplement that. I think that is the aim of that. But I have not read the verbiage, so I can't speak to the exact language. The way I'd heard it always, I was very supportive, because I agree. Whether you become self-employed and make your own business, or and it doesn't have to be where you're wildly successful. We all struggle and are fledgling when we first start, whether we're W-2 and an unskilled person, as we build our skills, and and plan for the future, or we're self-employed. I mean, we all start with nothing unless we have like rich parents, which most of us don't. Sunflower says, are there any reasons not to file for long-term disability through your employer while waiting for SSDI decision? And is it okay to share the LTD forms filled out by your doctor with your SSDI attorney? Great question, Sunflower. I do not know of any reasons not to file for long-term disability through your employer while waiting for an SSDI decision. I mean, if you have LTD through your employment, that's a piece of compensation for the work you did for that company. It's part of your salary. That's the way you guys arranged it. And there are other times when you don't have LTD through your employer, even though they have it, because it was a voluntary optional, and you would pay a little bit out of every paycheck. I kind of think if it's low enough, people should do that, because honestly, disability is sadly very common. We're just a very unhealthy society, and you know, we're all dropping from something, right? So I don't see any reason not to. You may as well take that money. Now, note, of course, that most of you probably know this who have done this, LTD, most policies through employers now have a clause in them that make the premiums cheaper for the employer that says when you collect LTD and we pay out, you have to file for SSD. And if you prevail, we get to drop what we pay you by the amount you're getting from SSD. So you're not getting paid it both ways. So like an LTD who's paying you $2,500 a month, and if you're getting $2,000 a month from your SSD, they will only now be paying you $500. And that is prospective benefits. And that's all private contractual stuff. Has nothing to do with Social Security law. That's just the way my little bit of knowledge of that little industry goes, just from touching on it. Keep in mind, if your retro SSD payment for your back benefits coincides month per month with any LTD, long-term disability through your employer payments, your LTD policy probably says, and you're going to owe us back the amount that it would have been offset. And so they're going to try to get you to pay your back benefits to them, or part of it to cover their payments that they made for you for the same month back then. And as I always say, that's a private contract between you and them, just like your credit card bill is, your rent is, if you have car payments. And some people think that I would go speak to someone about this who does this for a living, LTD, but it's a business contract you have with somebody like all your other ones. So should the LTD come first? Not necessarily. You have limited monies. Where are you going to spend them? You need a new roof, or you pay your LTD debt. Now, if your LTD is going to be paying for the next 10 years, if you behave, and even if it's only that $500 overage every month now, that might be enough of a reason for you to say, yeah, I'm going to make sure that I pay them the back benefits to them instead of this credit card, or Grandma Josephine gave me $20,000 for my new roof when I didn't have the money. You're going to have to figure out what takes priority. But I know some people just automatically assume, they think that SSD will cut them off if they don't pay LTD. And no, that's a private business relationship you have with that commercial insurance company. That is not SSD. SSD will not get involved, and it will continue to pay your SSD no matter what. How you spend your SSD in that regard will be up to you. And I'm always just saying this because the assumption, and I don't know why it's there, is that, well, LTD, I should pay that first. Should you? I don't know. Maybe not. Evaluate everything. Maybe other bills are priority. Maybe paying your mortgage that you're behind in 3 months would be a priority, or your car payment because they can repossess. So there's always, I would say, think it through, take notes, jot things down and figure out what you pay first. Oh, Valerie, you too. Valerie says it's always nice to interact with you, Stephanie. You as well. And thanks for being here. I know you can't always make it, so I appreciate when you do. Second phone says, during SSDI hearing, judge asked if I could go back to my job. He asked the VE, the vocational expert, no, he probably didn't ask if you could, because they have to do it in hypothetical form, but I know what you're saying. The VE said no. So the VE was basically saying that hypothetical person you just described, Judge, no, that person could not do the claimant's prior. But then the VE said, but 3 others. So couldn't do past relevant work. That hypothetical person that may or may not be you once the judge makes up his mind. But that's step 4. But then step 5 is there any other jobs that that hypothetical claimant could do? But 3 others. Then judge asks, with limitations. So the judge added some more limitations. That's new hypotheticals. The VE then said no jobs twice. Is that a good sign? It's a good sign in the fact that the judge has left himself multiple options of RFCs, residual functional capacities, to apply to you. He had the first one where there was 3 jobs. He had the next ones where he added additional hypothetical limitations. He has to determine if he finds in the evidence after hearing whether those limitations are well substantiated in the medical evidence. And if so, he might find that you, based on your medical records, do fit that 4th hypothetical or whatever, where the VE said there's no jobs, and then he could find you not disabled. It's always troubling when you go to a judge and they ask one hypothetical and there are jobs. And then he goes, counselor, I'm done. Do you have any questions? And I'm like, absolutely. And then I go on to multiple other hypotheticals with more limitations that I find are in the record, and I want the judge to find that too. Although the fact that the judge only gave one hypothetical with none of those limitations always has me worried if that happens. And of course I disagree. And then we have to go to appeals counsel if the client so desires. Okay, art of the practice. If a claim is at the reconsideration stage and the claimant's DLI has passed, if a claim is at the reconsideration and the DLI has passed, for example, DLI of end of 2024, I've got a few of those there, Art. Is the adjudicator only allowed to review records up to the DLI? Essentially, I think he's going to see all the others, so I would keep sending them in. However, he can't use them to substantiate a finding that you were disabled before your DLI. So if you have and there could be deviations there, that's a general rule. But let's say you had a week after your DLI, let's say January 7th, Art, you had an MRI that you didn't have before that showed severe stenosis, compressed nerve roots coming out of, L4, L5, all these objective things. That stuff doesn't happen overnight. So you'd like to think that they can kind of say, well, we see it here. Yes, this is after his DLI, but this stuff doesn't happen overnight. And he was complaining of that very same kind of pain that would be caused by what we now know to be nerve impingement, 9 months ago. I don't know that at the reconsideration stage, they allow themselves or so much discretion to make that connection of the dots. That makes sense. I do think judges can if they want to. They just have to really do some stretching. That's why it's really important to get that strong evidence while you still have a DLI. I know a lot of people are like, but I don't want to spend my savings on copays. I'm like, okay, it could be penny wise and pound foolish, but you increase the chances of losing your case. And I don't know how this works exactly, but let's say you do win your case and you spent all this money out of pocket for health insurance because copays and deductibles or you didn't have any, but you had savings and you went ahead and used it, which is a really scary proposition, I know, because it's like a nest egg for, emergencies and mortgages and rents and stuff. If you were to have had Medicare retroactively, which a lot of cases do if they take a while to win or if your alleged onset date was retro, you can, and they actually try to get you to, pay, this is going to sound weird, pay retroactive Medicare premiums for all the months you were eligible for Medicare, but are in the past, while your case is pending. And you wonder, well, why would I want to pay for that since I can't even use it? It's in the past. I'm wondering if you can get those bills now reimbursed. If there's, I don't know the answer, guys, but I think it's very possible that there's something in the law of Medicare, perhaps, where if you have retroactive Medicare and you pay those premiums, so the premiums are say $180 a month, you have $15,000 you laid over the last 2 years, which you retroactively now have and paid for Medicare, that you didn't have it in real time, you could potentially get that money back. Medicare now has to pay what you paid and you get refunded. Big headache, I'm sure, but for $15,000, it might be worth it. Something to look into. I don't know the answer. I'm putting it out there just so you're aware that maybe it's something to look into, see if that's possible. Art of the practice. Or can they consider records beyond the DLI to confirm the disabling condition has continued? They definitely do that, Art, because you don't just, you're not your job is not limited to proving that you became disabled back when you were insured. That's one thing you have to prove. And the first one. The second one is that it continued to the present, which is going to be long after DLI. So, because if you have a gap where you can't prove that you're still disabled, which is why I say don't have big gaps, guys. Keep treating. You know, you have to prove that you're disabled up to the date of the ALJ hearing. And if you can't, it could mean a denial, or it could mean he gives you a partially favorable in the form of a closed period. Well, he found that you were disabled 3 years ago, but he found that there's nothing to suggest you're still disabled after 10 months ago, because there's been no treatment since then. And I've seen people get closed periods, and it's a little annoying for them. You know, it can happen when a body part has surgery and it's healed, and it's not 100%, but it's no longer as limited as it was, and now there are jobs that can be done with the less severe limitation. Pardon me. Remember last week we went like 3 hours? Was it 3 hours? I was parched. I kept forgetting to drink my water. Wait, hold on. Art has the last part of his sentence. Or to view objective evidence like MRIs that confirm the alleged conditions. Yeah. I have seen, this is the flip side of that, Art. In one case, this was like an amazing, miraculous case. And it had to do with a 9/11 front first responder. And it was like 20 years later during COVID. And I took it just because someone's got to do this. Someone's got to try, even though it was like brink of impossible. But there was a pulmonary test from, say, 2004, which showed now this lung thing, which wasn't what disabled the guy fully. But by the time we are going to hearing, now the person's much older, different age frame. She took that test from 20 years ago and said that stuff doesn't heal. There's no cure. So she did apply the finding of that lung problem from 20 years ago and nothing since, no treatment since, to still exist like in 2020. I don't know if it was 2024 or 23, whenever, even 22. It's been a couple years. So she was able to extrapolate it out, and it was something that I hadn't thought of. So the judge really helped save the case. Part of the strategy I like to do, and it's just an honest strategy. I like to show the judge all the reasons why they would want to, why they need to know this person's disabled now. Because I feel like I want to give them a reason to really try to help find the evidence in that nitpicky little file, things that we might not recognize that the judge happens to have an inkling, you know, one of their favorites, that kind of thing. So I feel like part of it is just human nature. You want to persuade the person that they agree with you overall, and then, you know, it's supposed to be a non-adversarial process in its entire SSD. So if you believe they're disabled now, let's see if we can find all the things that will satisfy, you know, your needs for the written decision and the support to, you know, substantiate it and be able to cite to it. And that's what happened, and that was amazing. I was using a different strategy, but she didn't like that strategy. She liked this other one. And I don't care which one she goes with, you know what I mean? But we gave her so much that she knew it was so, but she wasn't comfortable using the strategy we had to fill in the gap to the present. She found this other way. So it was pretty impressive. It was amazing. I loved her for that. Okay, so You Served says, thanks for the information. My last question. Thanks to all veterans that served in your hubby also. Oh my gosh, yes, I thank the veterans too, every day and every time I see them in person. It's just super important to me. And I will tell my husband you said that. And you too, if you served, because your name is You Served, You Deserve, so you're not really talking about yourself, right? Maybe you are, though, as well. Maybe you're in the collective. Dimple says, I want to thank you for all the information you have given about making sure that things in our records. I asked my therapist about including info on having to change exercises due to hand-elbow issues. He completely understood and has been including the fact that my grip and limitations for lifting creates the need to adjust or limit pushing or pulling due to the RA in my hands. And excellent. So he sounds like a really good therapist who's not just like going through the motions. That's really sweet. And it's, you know, I think, did you know I touched on this, Dimple? I'm always warning about when we open our mouths and slip out that we're even have an SSD claim, because some providers are not going to look favorably on anyone who files a claim. They think everyone's just money hungry and faking it and stuff like that. Ironically, the very provider that's treating you for a condition. But there's just that bias out there, and the medical profession happens to be one of the probably the worst, most biased collectives, you know. So I'm always warning against it, but in this case, it worked out just fine for Dimple. So remember, when I say things, guys, it's general. It's my general impression. Doesn't mean it applies to everyone. Like, her therapist is very understanding. My usual motto is, you know, don't just assume that your doctor, because he treats you, is going to be supportive of a disability claim. Very often they, or gosh forbid, their office staff is not, and they will weed in some really damaging BS into your medical record. But at least not the majority of people, of course. I think most are professional, and even if they have an opinion, they don't let it interfere. But you know, what if 10% are? It's you know, if you have 5 doctors and my other client has 5 doctors, now at least one of you is going to get screwed if it's 10%. You know what I mean? So I'm always like, don't say anything unless you have a really clear indicator from your provider. Like, for instance, if he says, you, my dear, cannot go back to work. You are going to really hurt yourself. Your body needs to heal. Let's focus on this, get you through this, and then maybe we'll look at that in a year. That would be fine. That means he's supportive, sounds like. I do get worried about the bias, because I've just seen it I see it so often. You know, it's so funny. They'll do a lot of cut and paste for the past, and they don't seem to, generally, a large portion don't seem to make very good current records. Yeah, but when someone wants to stick it to a patient, they should be sure to get that one in there, right? You serve says, if I have a workers' comp settlement pending, how can I protect my SSDI payment coming in without getting hurt? I heard I need to settle with some sort of language or lifetime offset. Yeah, so speak to your workers' comp attorney. I don't do that kind of work. I have a colleague who's a workers' comp attorney, and I try to limit my questions to her because it's very complicated for me. And she limits her essence. She just sends her people to me, and I send them to her. But we don't have a total understanding of how it all relays. However, it's called the 80% rule, so you can look it up. You serve, if you call the local field office, you can ask them, what is my average, my ACE, I think it's called, average current earnings. I need to know it for my, you know, the possibilities with workers' comp later. ACE, ACE, I think, average current earnings. And they run a calculation. There's a few ways they do it, and they find out the one that's most favorable to you, I think. You want your average current earnings to be as high as possible. So I know one of the calculations involves, I think, in averaging the recent 3 years before you stopped working or working SGA. Maybe it's before the data onset. Not sure exactly. And then your average current earnings per month. So put that number off to the side. Then also take 80% of that number. Write that down, keep it off to the side. Then what is your SSD going to be right now if you win? And what is your workers' comp for any month you get SSD? Workers' comp tends to be a lot higher, right? Well, not necessarily, but yeah, oftentimes. If you take your workers' comp for that month and your SSDI that was paid or will be paid for that same month, retroactively or prospectively, add them together. Are they bigger than that 80% number? Not the 100% number. Are they bigger than the 80% number? If they are, there's going to be an offset. You're either going to be workers' comp is either going to be offsetting or SSD. There's like reverse offset states and non-reverse offset states, and I don't follow any of it, and I don't want to. But that's something. If your combined amount is, and by the way, I think they include family amounts in there. If you have family members, are you going to get an auxiliary benefit? Unfortunately, that's included in that too. That's the workers' comp and the SSD, and then over here you have the ACE and the 80% of ACE. Anything over the 8, if these two add up, let's say ACE, the 80% of ACE is $800 a month. Let's say your benefit per month is $1,000. I'm sorry, I'm over speaking now. Let's say your ACE, your average current earnings before you stopped working, was $1,000 a month. Your 80% of that would be $800. That is the most you can get between your SSD and your workers' comp when you add them together. So if combined they are $1,000 a month, you're going to have $200 too much that's going to have to go back to either SSD or workers' comp. Am I explaining that? And for many people, now you'll notice too, if someone is a high income earner, the chance of workers' comp and SSD in any given month received breaching 80% is far less. So the higher income earners don't tend to get whacked by the 80% rule, whereas lower income earners do, because the 80% rule, it's supposed to be trying to prevent it from being ultra lucrative to be collecting workers' comp and SSD and being disabled and making more money than you would if you worked. That's what that kind of boils down to. But you can find out that ACE by calling your field office. They should be able to give that to you. We've done that before. Well, my clients have done that before. Consultees have done that before. Sunflower says, my specialist filled out forms for LTD. Is it beneficial to, oh, I'm sorry. You did ask that before, Sunflower, and I blew that off by mistake. I'm sorry. It can be. If your SSD attorney gets anything, they are obligated to send it to the SSA. So hopefully it's good. Under SSA definitions are good, not under LTD definitions. Usually it'll kind of coincide, but not necessarily. So it can be a double-edged sword. We have to send in everything we get, good, bad, or ugly. We are not allowed to cherry pick. It's not the same. We're just not. And neither is a claimant technically allowed to not send in anything he has, even if it's bad for his case. Yeah. And that's, I think they get away with that because it is a non-adversarial process. In theory. Wayne C. from Kentucky. Hi, Wayne. Hey, Shub is in the house too. Hi, Shub. And me is in the house. Don't they send a letter to your doctor asking how bad they think you are in their opinion? It wouldn't be so vague as that. How bad is she? They used to send, yeah, the kind of thing they would add a consultative examiner. Instead of the person having to go to a consultative exam, they would send it to the treating doctor who already has examined the person. Treating doctors were not really wanting to do it. So, and a lot of times you'll see in the file that was the treating doctor asked for, you know, CE and there'll be a notation that declined. And I think there are some doctors that they already know decline automatically. So they have that automatically in there. They don't even ask them. Yeah. So they don't do that as much as they used to, and me, because of that. And I think a lot of times the doctors don't want to do it because they're afraid that if they say something that is accurate in their mind and it makes their patient lose his case, you know, they're like, well, now I just screwed over my own patient. Now I might lose a patient because he's going to be ticked off at me. And because the doctors don't know what some of those definitions are of what they've been asked to comment on. Like, is he mildly, markedly, or extremely limited in this, or not at all? And if they want to say moderately, yeah, he's moderately impaired there. Well, guess what? That might very well mean not disabled, just impaired. So what is interpreted as being very bad for the doctor, you know, in his opinion, is not legally going to be, it can legally support a finding of not disabled. The exact thing that you're not wanting. So I think that's why some doctors don't do it. I kind of don't blame them for that. I would like to think that if they were given a little education on it by, say, the claimant's attorney of what the different things mean, it would be nice if they would be willing then to do it. We give them some informational stuff from the SSA so they know exactly what their definitions mean. If and when we do these, which is really depends on the case and the doctor and stuff. But because we don't want them blindly answering when they don't know what something means that they're going to be saying. You know, if they're going to check a box and they don't actually know what that word means under SSA rules, because what's under SSA rules is not necessarily how we all otherwise think of it, or some of us, you know, different cultures, different words mean different things. I remember once, many years ago, when my son was a baby, I got LASIK eye surgery. I was trying to get away with not wearing glasses for a few years because I probably have them here. You guys have probably seen me. They're more for distance, but they're always dirty. But anyway, this is just one of my many sets. I have like 8 pairs because I lose them. I get really cheap ones because I will destroy them. So I got LASIK. I saved and saved and saved and saved. And I just, you know, I wanted to be able to hold my baby without having these glasses on my face. And he was already like 9 months by the time I was able to get it done. But I remember, and I had to get it done twice, like within the healing time, because it was so bad. My one eye was so blind. So anyway, I remember the doctor that does all the follow-up visits, not the famous on television LASIK dude, but one of his associates. And she would always say, well, you know, your vision was very moderate. And I'm like, it sounds like she's saying very bad. And it was. I was like it would be like Coke bottles, you know, if I had glasses on. But in the SS world, moderate doesn't mean very, very bad. It just means more than mild. So, you know what I mean? So everyone's knowledge, I always think back to that, how she used to always say moderate, and I knew she meant I was really blind, but she didn't use the word extreme and she didn't use the word severe. She used moderate. And like, don't we all like to think of ourselves as moderate politically, moderate this, like moderate socializing with alcohol, moderate this, So I don't know. It has different meanings for different things. And she meant it as pretty severe. And if I was disabled and that was in there, I'd lose my case. I wasn't disabled. I was just, visually impaired, visually challenged. All right. So Muley says, will my wife get part of my SSDI? She turns 62 next year. No. She will never get part of your SSDI. If you are collecting, which it sounds like you are, when she turns 62, she can file for an early retirement benefit that will look at her own work record, see what that is. And she doesn't have to prove she's disabled or anything to collect it. Or if taking 35% of your primary insurance amount is better than taking her own, she'd get that amount. Remember, if she files at 62, she's taking a reduced amount regardless. If she's going to collect under her own record, because that's higher, it's still going to be like 70% and never 100% forever after. It's a permanent reduction if you collect at 62. And similarly, if she takes a spousal benefit at 62 because it's better than her own, and they're going to, when you file for one, it's deemed a filing for the other. She's also going to take a significant reduction. So instead of getting a full 50% of yours that she would get if she waited to 67, she's only going to get like 35%, something like that. So her taking early is always going to penalize her. And I say penalize her, it's not really. She's getting more monthly benefits. Ergo, each one is a little smaller because I have to scrape off the top to make up all those extra payments. She should think long and hard about maybe, collecting that early. She's not disabled. Maybe she should just work a few more years. That's really a personal choice, though. But it's never going to come out of yours. It is going to be in addition to. Anything she collects based on your work record will not touch on yours. Yours is not going to get reduced. Okay? It's an auxiliary benefit. It's extra that you worked and paid for. She could do that if she wanted. Erin says, I was denied a month ago. I'm sorry, Erin, and have a hearing scheduled in December. Okay, so you were denied on reconsideration, and now you have an ALJ hearing scheduled for December. I am agoraphobic and on the spectrum and don't think I'll be able to communicate well. Any options? Well, first of all, your lawyer can help prep you for that, so that is something to consider doing. I assume you're going to have a prep time. I think sometimes the inability to communicate well can be in your favor, for what that's worth, because if you're on the spectrum and part of that is a communication issue, and that's in your records that you have one, and then you are in front of the judge having difficulties explaining things, but he's also going to have your function report from before, that might just help confirm that you actually have those communication problems. I mean, you probably can't win on a communication problem like that, but it certainly will be supported in the records. And maybe it means you can't do public speaking jobs, and maybe you can't do, those kind of with a lot of people, maybe high-end supervision with lots of people. It came up, was it on here last week, guys? Somebody asked about, should I do another function report for the judge? Now, the judges don't ask for a function report because they're going to hear your live testimony, which is essentially your function report, but live, speaking to it. But Erin, it could be, I was rethinking about this and I was talking about it to whoever. I'm like, maybe that wouldn't be such a bad idea. As long as you make sure if you want to do an updated function report, particularly if you feel you're going to have a poor time communicating live and you want him to know what's currently going on because the function report you did before was 18 months ago, that's something I would look at your old ones and make sure you're not misinterpreting anything, or maybe the way you're wording things today is not as severe as the way you worded it before, but you definitely haven't gotten better. You might want to tailor that and make sure that the trend is showing the realities that it's gotten worse, not that you've just gotten fluffier in the way you describe it because you're just so used to it now, even though the pain has not gotten better. And then when you go to hearing, make sure you've kind of studied that, to make sure, because it's not a matter of honesty or dishonesty. It's a matter of what day we just as humans describe things differently than another day. We might say I can walk 50 feet today, and a different day, word 70 might come out of our mouths, because no day is exactly the same. So, and you can always say that no day is exactly the same, but I would always look at, and we do this when we prep for hearing, look at the most recent function report and go over it and say, has any of this changed? Would I want to describe it differently if I'm in front of the judge? And if I do, I could say, Judge, when I did my function report, this is what I was perceiving, but it has since gotten worse, and now this is the way it is. something to say. But at least then he'll have it in writing, Erin, so that if you don't articulate it well, you could say, I'm trying to explain it, Judge. I'm just not good verbalizing things. That's why I sent you a function report. But I'm still going to try here, Judge. But I wanted to make sure you had that, because in case I screw it up, what I do when I get nervous, I didn't want that information to be, not available to you. Supreme says, herniated disc in neck at C3 to C3, C4, far right lateral, and in lumbar L4, L5 with annular tears, spinal stenosis, osteoarthritis and bilateral shoulders, hips, bilateral labrum tears, IBS. What are my chances? They don't have a book on that. You know that, Supreme. There's no book on chances. If you are under 50, it's probably still a low chance. If that's it. If it's over 50, there's better chance. But there is no book. They don't break it out by impairments. Think about how many overlap. Like you have a bunch that are overlapping. Someone else might have osteoarthritis and bilateral shoulders, and then they have something different, like maybe severe agoraphobia. And there is no book that can parse that out. Because it also depends on age, right? And prior relevant work. And education, in theory, really ever see that much affecting anything. But definitely the prior work experience. Drink your water, everybody. Even if you're not yapping away like I am. Anne says, I saw a letter to one of them in my portal, then it disappeared. You saw a letter, was this the letters to the doctor? Oh, it should never disappear. So they shouldn't be able to take anything out. I mean, if it's in there, that means they sent it, right? Then it disappeared. How did you see it in your portal? Oh, you mean in your doctor portal, your patient portal, that he had received it? That means your doctor's office took it out. I don't know whether they can or not. I suppose maybe they can, since it's not a medical record. It's just a correspondence. Gemini. Hey, Gemini to Butterfly. 60-year-old had stroke on June 18th, 2025. Oh, that's recent, Gemini. I know we talked about this last week, right? And filed on, oh no, wait a minute. Do you mean 2024? And filed on October 2024? On August 7th of 2025. I'm going to guess here. Gemini was told need to do 2 CEs on August 22nd, 2025. Okay. And September 3rd. Okay. What's taken so long for the initial to be reviewed? Oh, I suspect you didn't have an adjudicator for many months. If you filed in October and now just this summer they're getting onto CEs and stuff like that, you might have been going till May without an adjudicator. Because remember, there was such a shortage for a few years, and now they're trying to build those up. But, it was really hampered. And in 2025, they're starting to change that, but it's still a slow go. My guess is you didn't have an adjudicator. You were waiting in that bullpen of sorts for the next opening. Or one of the next openings. Muley says, should I have my shoulder replacement doc give a report of my shoulder disability? Well, that depends. Is your shoulder doctor so poorly drafting records that it doesn't make clear how bad it is, how much it affects you, your complaints, as well as, the objective diagnoses and condition and all that? Because if he's not doing it there, what's the chance of him doing it well otherwise? And will he do it anyway? So you have to, look at the records. Do they spell it out? I mean, him saying it because a patient asked him to is not going to be as strong as what would be organically in his records because it came naturally from him. Having to get a report from your doctor means that the records are not that very good. Supreme says, also, FAI, what is that? FAI? Something information? For all information? Just had my ALJ hearing last week in Las Vegas. Can no longer get steroid injections due to high eye pressure. Oh, do you have glaucoma? Is that like a glaucoma thing? My father had that. No more steroid injections because it makes sense. Yeah, hopefully that's well documented. I'm sure it is. Can't do it anymore because your eye pressure is going up. Sorry about that, Supreme. And fingers crossed on your ALJ hearing results. I hope you prevail. Virginia says, we're at the 1 hour mark in case anybody wants to know. It's about 2 o'clock now. Virginia says, I was going for non-medical hearing with ALJ and ended up getting denied for medical. So what did you appealed for a non-medical reason? What was that non-medical reason that you appealed to an ALJ for? Virginia? That's what I need to know. What do you think you appealed? Like, what was the non-medical issue that you wanted adjudicated? Because it was not considered a non-medical. Sometimes people think I just wanted to appeal the onset that they found. I didn't want to appeal the finding. Appealing the onset, if you don't agree with the later onset that they gave you and you appeal it to an ALJ hearing, that's a medical appeal. You're appealing the medical finding that you were not disabled prior to that much later date that you don't prefer. That's a medical appeal, not a non-medical. If that's what you did, Virginia, and thought it was non-medical, because I'm not trying to change anything about the medical finding. Yes, I'm disabled. I agree. I just don't agree with the date that you said it's evident. That's a medical, unfortunately. But I don't think that's what happened to you, right? I don't know. R&D says, R&D, my question is getting skipped. Let me see if I can find it. I would never skip you. I wouldn't skip anybody. Certainly not one of my favorite regulars. RD. Oh, wait. Is that a different one? That's not you from California, right? Yeah, it probably is. All you said is from California. I didn't skip you. Did you want me to say hi, California? Or is there something I'm not seeing here? Give me your question, RD. You know I'll answer it. Oh, here it is down here. Okay. Let me, I'm going to do RD, La Lulu, and then I'm going to come back up to you. RD says, my claim is closed at DDS and was sent to the local SSA office. How long before I get an answer? Well, they usually say that's that 15 to 30 day non-medical review, right? I would say give it that. I have a client right now who was in the 50 to 30 day. Now we're at like day 33. She still hasn't heard. She's going crazy. I don't blame her. Lulu, hi there, La Lulu, says, question, opinions if I don't agree with wording on latest treatment plans. Providers attempt to be positive and hopeful, but I truly don't possess or have access to environmental assets or strengths as listed. Is that mental health? If that's mental health, La Lulu, because you're saying environmental assets or strengths, I would speak to that therapist or that whoever that is. I mean, even if it's physical and I'm mistaken there, and just talk to them and say, like, you note that I have this, that this is not true. I do not have a strong financial support system from my family or whatever. You know, they can't send me for a treatment or anything. They don't have the money. They put a roof over my head, that's it. Or emotional support or what have you. But yeah, I think if they're surmising you wrong, maybe you want to have a clearer conversation. Obviously, honey and not vinegar, because people get upset with us if we're not super honeyish, even if, you know, it's like beating your head against a brick wall, right? And it gets a little tiring. All right. Oh, Deb Lindley, I was thinking about you. Oh, I've been thinking about you almost every day. She says, hi, sweet girl. Hope you're doing well. Sorry, I haven't been around in a long while. No, you haven't. And I've seriously been thinking about you every day. Not doing well at all, in and out of hospital for months. Oh, Deb, I had that worry. And I was giving you daily prayers because, you know, you're always around giving positive thoughts here and you weren't. So I figured you were going through a very tough time. So I will continue to think about you and pray for you every day, my dear. And thank you for stopping in. You might not even still be here because if you're resting, but it's really thoughtful of you to think of us and come pop in and say hi. And I hope everyone here gives her some positive vibes and some prayers and all that good stuff. So Deb can have as much support as she can through this really, really tough time. Virginia says, Virginia Gomez, question mark, how much time does an ALJ need the medical evidence before the court hearing? Okay, there is a 5-day evidence rule. I say go ahead and assume that's 10 days because 5 days is 5 business days. So it's always going to be 7 because of the weekend, and then sometimes 8 because of a holiday. That includes evidence or a letter explaining to the judge, hey, here's the outstanding evidence that isn't available yet. If it's not available, but you've been asking for it, which is basically you have to have been showing that you've been asking for the records all along, give or take. You want to explain to him that you've made best efforts. You're waiting on this. It's been very delayed, blah, blah, but please accept this as a 5-day evidence letter and potentially give time for this to come in after hearing. Sometimes it's about evidence that isn't already happened, visits, but you're having an MRI in 4 days after the hearing. He might just want by and large, he's going to want that MRI or whatever else it is. It's so objective, Sometimes they'll give you anything you mentioned. They're going to give you the opening for it. And this is true too, even if they're going to deny you, because they can't really deny if they could be subject to appeal if they didn't wait for it. So they'd rather go with a stronger denial that won't be overturn an appeal as easily. And so they're always going to bend over backwards to give you the time. So there is that negative too. But 5-day rule, I say pretend it's 10. Yeah. And that would include a brief if you're going to do a brief or an argument or evidence or the 5-day or the letter that says why something's not in. You have to explain it. I think the rule says you should explain how you've tried to make sure it's in. We kind of keep it. We do the same routine the way we order. It's kind of like a McDonald's assembly line, like make sure everything's done in the steps, so you're always well ordered before the hearing and the dates, all that. And then it makes it very easy to know when something hasn't been provided by a doctor, and we can have a very exacting 5-day letter, so we always know we protected the client from any missing evidence that the judge is going to let us have time extra to get it in. Deb says, she's talking to Supreme. All right, I'll let that stay between you and anybody watching the chat. Spine surgery journey, how you doing, bud? At 56, how many back surgeries does it take to get SSDI? Many times none. Already getting third. So it's not the number of, but for sure, I would think if you're having 3 surgeries and you're not claiming that all the rest made you like you're 20 again, if you look at it, like, what is the back surgery proving? If it's proving at 56, you only have to prove, for a grid purpose anyway, spine, that you can't do medium level work. That's over 20 pounds of lifting and on your feet 6 to 8 hours. So and that could be up to 50 pounds, and usually multiple back surgeries or even one, there probably is going to be a weight limit of like 40 pounds for the rest of your life, or that's if you have a good recovery, right? I'm just kind of pulling that out of the air. I'm not saying I'm a medical doctor, but I always, feel like it's going to be, we don't want you lifting that 100-pound bag of whatever anymore. Your back already couldn't take what you were doing in life to begin with. And now, so I think you're waiting for hearing, right, Spine? You got yourself an attorney. I'm trying to remember, but it's not whether how many back surgeries, because people can win without a back surgery for a back problem. But certainly the fact that you have 3 means, and they're probably not all in the same spot. Maybe there's 2 uppers or 2 lowers and an upper, or I don't know. It can help you. I mean, you do it for medical reasons. I wouldn't say have the surgery for evidence reasons, but it does show that you have an impaired back that is continuing to have these great needs. And I think it would be a very strong indicator that you cannot do medium work unless you talk about how you're doing it. So don't be doing it. Medium level activity, I should say, exertion. La Lulu says, question, upcoming functional consultative examination. It says to bring all prescription medications, including devices. Do I bring psych prescriptions such as prescribed light therapy box if it says functional CE? Yeah, why not? And what do they mean by functional? Physical? And functional, that's a CE. They don't usually use that word, because FCE is usually what we see in workers' comp. Functional capacity examination. That's not really the same as the CEs we have here, although there's some similarities. Have more questions too if you have video link to refer. I would follow the directions. If they say to bring all meds, bring all meds. I don't know why they just can't take a list of them. Maybe because they think people forget them, or maybe they're suspicious. It's funny about the devices, though. It's like, what if they're big? What if you have a big ass device? I don't know. Yeah, I mean, it is. If the light therapy, I think that's for mental health, right, Lulu? If it's a prescription, I would bring it, I suppose. Oh, Supreme says that FAI is for more. Oh, I thought you were doing like, people go, for your information, FYI, or okay, femoral acetabular impingement. I have suspected glaucoma and also osteophytes throughout the spine, indenting my thecal sac. Also, I am 3 months from 49. That means you're 48. Yeah. I hope you're keeping your credits up. Your DLI is so important right now in case this flies south for you under the age of 50, Supreme, so you can file again. If you don't know what I'm talking about, just ask, keeping your DLI prospective and ahead of you. is probably the single strongest factor to being sure to at some point win, you know. And that's the biggest, I want to say, safety net or insurance policy you can have is being able to do that in a way that does not jeopardize the status of being disabled even before you've proven it. Hello, Matthew McGraw. Good to see you again. RD, thank you. You're welcome. Thank you. Eddie Garcia. Had to leave earlier, and I'm back now catching up on the earlier part of the video. Thank you again. You're welcome. I don't know. Can you even see it? Oh, by the way, I want to thank, I'm told I should say this in the beginning, for the replay people. Thank you for watching the replay. We're live now, but yeah. I meant to do that. Old habits die hard. I just got to jump into it. You guys know how it is. I'm usually popping from one thing right into live stream. But yeah, the replay, I appreciate them checking in. Ryan Perez. Hi, Ryan. I don't know that we've met. Does the DDS always request a physical and mental CE on every claim? No. I will say vast majority, though. If you claim physical, you'll probably get a CE. And if you claim mental, you get a CE. So if you claim both, you're probably going to get both. And the times when it's not, the person is usually going to win possibly listing. So it's rare. Listings aren't that common. And it is, I don't even know the last time I've had a client that didn't have a CE exam. I got a client on Recon who didn't have a CE exam on initial. I think it was just a mistake on the part of the adjudicator. Just dropped the ball. So they're getting it now. Eddie Garcia says, and the Zelle idea is great advice. I didn't think of that. Oh, very cool. Awesome. Yeah, sometimes these technologies are helpful, right? There's Zelle, there's Venmo, which is another one. I don't know the difference. I know that like the Zelle has to go through your bank. Your bank has to be amenable to it. Versus like PayPal or Venmo. Rat's Nest, good to see you. Hey. On my SSDI page, recently went to Recon. It says they're sending me a pain and fatigue questionnaire, okay, along with the new functional work history. Yeah, they were kind of proprietary depending on the office. Like they made them up themselves, a pain report and a fatigue report. And as of this past year, now when we, like if my client has that and now they're getting them more often, there's actually a label that we can, when we do the drop-down menu to upload as the attorney, directly into the electronic file, there's now a label for a ton of different reports. Pain, fatigue, headache, this, that, the other thing. It used to just be function report. Now they have all the different variations. You say work history report, usually they don't ask for that twice. However, if your work history report that you submitted on initial was before June of 2024, that might be why, because that's when the new format came out that is a lot more detailed and robust. I prefer it. It's a little longer, but it helps you drill down on some of the really incremental factors of that job that people wouldn't otherwise have mentioned when the questions were more vague, and that really difficult little repetitive thing that you had to do that you wouldn't think of because it's not every day is now something that maybe you're prompted to remember and explain that you had to do this. But yeah, that's getting more and more common. In fact, to the point where I'm probably going to take a pain report and hope that they're all going to be the same across the country, like function reports are. Hope they become that way, because I will turn it into a form fillable form, so my clients can form fill it if they want, and it's easier for them than handwriting it. So just something I'm thinking about. It's not top of my list. I got too many other things going on right now with work. But RD says, stay strong, Deb. Indeed. Oh, love you back. Thank you for the prayers and support and thoughts. Everyone on this channel receives the same from me. Oh, super awesome. I appreciate that. Okay, Supreme's talking to Deb. Okay, La Lulu is saying that yes, for mental health, the exam is physical. I understand. If you want to be better safe than sorry, or what? I mean, if it's like I don't know if it's a bigger contraption, can you just be like, take a picture and be like, this is my late therapy. I didn't think you necessarily wanted that, doctor, because this is a physical exam, but I wasn't sure, so I took a picture. I don't know why they would want you to bring all that in. New York, the best. 2018, 44 years remanded. 44 years old. Yep. Oh, that's right. We spoke last week, right, New York? Remanded again from federal court, waiting for the ALJ hearing date. Been diagnosed with arthritis in my right hand, severe sleep apnea, fibromyalgia, and mild neurological disorder since my last hearing. Oh, all since. had a CE mental exam, and he said if I was bipolar, I also suffer with chronic bilateral lumbar radiculopathy, L4-5 and S1, sciatica, asthma, migraine, take Botox for gastritis. Yeah, you got a lot of stuff going on. Doesn't make for easy living, does it? And anxiety and depression. Why not throw that one in there, right, New York? You know, Matthew says, I received a letter from SSA, and one thing listed under contact your medical sources says you're encouraged to contact your medical sources to determine if they're willing to perform. Yeah, I know. And so it's really kind of up in the air if they're willing to, but that kind of shows you that they're very used to having them not willing. And that's probably what they're saying. Well, you, Mr. Claimant, can go talk to your doctor and see if he'll do it. So you could do that. One thing about the consultative examiners is they are familiar with what all those words mean, and which check boxes will define you as disabled and which ones will define you as not disabled and only impaired. So I do still have concerns about a treating provider doing that who doesn't have the explanations, the education in front of them, and has to be willing to read it. But maybe, it's really hard. It's like 6 of this, half a dozen of the other. I don't know what to tell you. Eddie Garcia says, yes, I'm currently on payment plans for my electric and water, and I haven't paid back my friend that paid for my rent a few times. That's what I just want to make sure about, but I could Zelle them. Yeah, and with Zelle, you can put a memo in there, and I think it's going to show up on your bank account. I do Zelle a little bit. I Zelle my kids. I've Zelled when I've had someone babysit the dogs if we go away. Yeah. And you could identify it, I think. Mooley says, appealed an offset, waiting for an ALJ. Can ALJ give a decision before the hearing? Generally, yes, they can. They could do OTRs. Appealing an offset. So that's a non-medical appeal, right, Muley? And how are you appealing it? Are you saying, if you follow my numbers, I didn't actually get overpaid? Are you appealing the fact of the overpayment? Or are you appealing a waiver denial or something? Rasness says, as always, and God bless you. Oh, you too. All right, we're at an hour and 20 minutes, guys. I'm not seeing any more questions. Are we good? Are we good? I'll give you guys a minute. Anybody have anything to share? Anything? I think we're good, right, guys? I'm just giving you just in case somebody's typing. But otherwise, I hope everyone's doing good, and I hope to see you 12 noon for the video shares. September's coming. This has been a really busy summer. Oh, Danny Ray. Hey, SOJ. It's RDM. I'm here listening. Oh, I thought from things you said that Danny something in the posts on YouTube was you, RDM, but I wasn't sure. And I think it was when you talked about journaling. I'm like, wait, is that one of my guys? Anywho, check out the message I said about the journals. Eddie Garcia. Oh, thank you. You are fantastic. Oh, tooting my horn here. At what you do and speaking with people and taking your time. We appreciate you. Well, I really appreciate being here, and I have so much fun on Wednesdays. I really do. Oh, Danny Ray said this is his first time here. Huh. But you probably contacted me because you saw me here, or maybe it was in a pre-recorded. The dailies at 12. Is that how we got together, Danny Ray? Oh, that's sweet. Cool. Yep. Okay. Good. I see that. It's all good. All right. Does anybody need anything? I'm actually going to try to go through emails that have been sent over to me that I need to call from evals that have gotten through the first step of, do we have openings? Yes, we have openings in that category. And that's supposed to be what I'm doing after this, making some phone calls. I'm going to grab La Lulu. She just popped a question in, or a statement. 60-year-old, so addressing all limitations that you advise. Yes, I think that's a good idea. I haven't received recent treatment on few physical ailments. Appointment for physical rescheduled after consultative exam. Do I mention CE or find another doctor real quick? Appointment for physical. Oh, meaning your regular doctor appointment for a regular physical was rescheduled till after you have a consultative exam. Do I mention that you have it at CE? I mean, the CE is not going to have all your medical records. So he's not going to know whether you're robustly seeing anybody. But you know how I feel. You got to get this physical. You're 6 years old. Those physical ailments are going to be what's going to help you grid, because you can't do it on just mental, right? I don't know that you have to tell him about your schedule. I don't know if he's going to want to know about it. He's there. Remember, he's getting paid a small amount of money. I understand correctly. Good. to do the exam. So, I mean, if you have like in the last year or so, even maybe 2 years if you're desperate, like a good MRI or something that shows pretty significant damage to something. And I always use the word MRI, but it could be something else. You could bring that, since it is a physical appointment, right? I think it's physical appointment. Yeah, you could bring some very scarce in medical records. Like I always say, no more than 10 pages, because the DDS often doesn't give them any, or certainly doesn't give them what you would think is more important. So you could do that. It doesn't necessarily mean a hill of beans, but you can do that. Righty. All right, guys. I'm going to call it a day. I don't think we have any other questions. We don't. All right. I hope to see you guys on Wednesdays at 12. And again, next week. September is balls to the wall. Hearing mode is coming in this fall. And some other exciting things on spine. You're just popping your question in now. On the work front. So it'll be no more weekends off, that kind of thing. It was a great weekend though. On my initial application, spine says I put 30 days before my 50th birthday is when I became disabled. With my symptoms, I shouldn't have a problem qualifying according to my attorney. What about my age? Well, 30 days before your 50th birthday is very close to your 55th birthday. So I kind of agree that you have probably a really strong case based on being 55 or older, even if you're 30 days before. I think are you heading to hearing spine, or you're on initial or recon? I mean, your 50th birthday has come and gone now. So even the recon people who might not have full discretion know that you're 55 now. At worst, I think if they're going to go with it, they could go with 30 days later on your actual 55th birthday. They might not do that rounding thing and take it on the 30 days before. But also that might be the exception where they don't have to. I think you have a good case there. You've had a lot going on. Be careful with that back. No heavy lifting. All right. Yeah, you're on recon. Okay, it's mine. Very good. All right, guys. Let's call it a day. It's been an hour and a half. We're good. We go 3 hours some days and an hour and a half another day. That's all good. Oh, Danny Ray, boss of the wall. By the way, that is not crude. I looked it up because I do say it a lot. And I looked it up a few years ago to make sure it wasn't something about body parts. And it really wasn't when you look at the history of what that means. So I could say whatever I want. All right, guys, have a great week. And I will talk to you next week. I hope you all come back. I'll talk to you later. And feel free to do comments on any of the videos, even if it's not related to the video. I really need to start keeping better track of suggested videos that people give that they want to hear something about. So, and I know I've been bad all summer, but it's been between, the various things that went on this summer, my thing, my husband's thing, and then we had this little mini vacation with the kids at the Jersey Shore this past weekend. It just really interferes, I suppose. But it will be strong and steady going now till probably Christmas. So anyway, believe it or not, it's really kind of relaxing for me when I'm not doing anything but working. It's really strange, but work is I don't know. It's a steady, I guess. But I'll talk to you guys later. Thanks so much for coming, guys. I'll see you next Wednesday.